Welcome to FCPA Flash, the official podcast of FCPA Professor, moderated by Professor Mike Kaler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com. FCPA Flash is sponsored by Kroll. Kroll is trusted by companies and compliance officers worldwide to help prevent, detect, and remediate FCPA challenges with scalable end-to-end compliance solutions. From high-volume third-party screening and automated monitoring, to risk-based due diligence, to complex investigations and monitorships. With leading experts, global resources, and advanced technology, Kroll is uniquely positioned to meet all your FCPA needs.
Thank you for listening to the FCPA Flash podcast. This is Professor Mike Kaler, and I invite you to my next FCPA Institute in Indianapolis on September 28th through the 29th. To learn more about the two-day FCPA Institute and how it has elevated the FCPA knowledge and practical skills of a diverse group of professionals, please visit fcpaprofessor.com and click on the FCPA Institute page. Welcome to FCPA Flash. This is Professor Mike Kaler, and in this episode, we have as guest Dan Newcomb and Cynthia Urda Kassis, both attorneys at Shearman Sterling. Dan and Cynthia recently authored an article titled Transacting Business During a Corruption Investigation that caught my eye. And in this podcast, we discuss various issues raised in the article. Thank you, Dan and Cynthia, for taking time to speak with me.
Thanks, Mike. Thanks for having us.
So what motivated you to write the article is my first question.
Sure. Well, actually, Mike, Dan and I have recently co-authored a couple of articles along these lines. As you probably know, Dan is a longtime expert in this area of FCPA. I'm really a transactional lawyer, but we've been working together over the past several years on a number of transactions which have been caught up in the ripple effects of Lava Jato coming out of Brazil, that huge corruption investigation. And we've watched how it has obviously implicated a lot of what Dan does and required a lot of advice on the FCP area, but how it has really implicated broad areas of business of our clients. Most of the work we've been doing has not been with the targets, but with lenders, with underwriters, with entities looking at buying assets from the targets of this. And we've been talking about how it's affected these transactions that we've been doing. So we've put together these articles and published them really not in traditional FCPA type digests, but in the Mining Journal, in Rocky Mountain, which is where I think you picked this one up, and in places in which our business as well as legal clients would be reading these.
Yeah, Mike, by way of illustration, we are underwriters counsel to Petrobras, and a lot of the stuff that we wrote about, I remember having the underwriters ask those questions when Petrobras did its first offering after the investigation became public. So that's the climate that we were trying to address.
Yeah, no doubt there's a lot of action in Brazil in the last couple of years, and no doubt that FCPA and related scrutiny has many different ripple effects, as you noted, and not just a government enforcement investigation. Now, companies or business partners of companies, really face potential legal liability all the time. What, in your estimation, makes potential legal liability under the FCPA or similar laws different than, say, legal liability under antitrust laws, environmental laws, or the host of other potentially criminal laws that apply to business organizations?
It's kind of an interesting question. I'm not entirely sure there is significant difference, both in terms of the the quantum of liability, the reputational risk that comes from being involved or around these kinds of situations, the general franchise risks that can come out of this. So I'm not sure there really is a difference, although I think particularly in Latin America and the ripple out of Brazil and across Latin America of Lava Jato, I think what it is doing is bringing institutions which are not institutions which are particularly sensitive to these issues, and maybe in many cases people within those institutions dealing with these issues for the first time. And so it happens that one of the first questions consistently we receive is, what are the fines? What are the legal liabilities of the institution that's the target, as well as people doing business with them? And from there, then the questions start becoming broader and more sophisticated, but it always seems to start with that question.
Yeah, I would say it is the fear of the unknown and an overactive imagination. That the other areas you named were areas that the non-target clients that we were mostly talking to had dealt with. They had, Cynthia's done many projects in Latin America that have environmental issues, and there was a well-worn path, a well-worked-out drill to manage and dimension the environmental issues. That was not the case in a number of the transactions we were involved in when it came to corruption investigations, perhaps because they were not very common in Latin America until very recently. But in any event, a whole, as Cynthia said, a whole cast of new folks at the clients became engaged in the transaction and didn't have, last year's deal to look at.
Mm-hmm. And they really were looking to us, and we worked with a number of groups of them in dimensioning, what were the risks they should be considering? How did the fact that one of the parties involved in the transaction was enmeshed in this multi-jurisdictional compliance investigation, how did that affect the transaction that they were proposing to do? And what risks did it raise, and how could you mitigate those risks?
Yeah, I mean, at the most basic level, many of our clients were financial institutions, funding transactions, and they were worried that they were funding corrupt payments. And so an early question almost always was that a violation by them if corrupt payments continue to be made?
And once they got past that, and they came to understand that there were ways, there were methodologies to make sure that by participating in the transaction, they were not violating any laws. They were taking the appropriate actions to ensure that everything they were doing was proper and was properly documented, properly diligent, executed. Then the next series of questions came out as to, okay, well, we can do it without violating the law or risking being fined. We can do it in full compliance, but do we want to do it? And do we want to do it then raised questions of what are the credit implications of the fact that one of the parties was involved in this. It raised questions about, the fundamental nature of the asset that may be purchased or financed, and was it a good asset, or was it about to disappear because it was obtained through corrupt practices? And then you go on and on.
Debarment is the other one that Mike is familiar with. That's a very common collateral consequence of a conviction.
So it sounds like the uniqueness here is really the newness of this focus and form of liability in Latin and South America, which Dan then begs the question, I guess, what do you account for being the root cause or root causes for the increase in bribery and corruption investigations in Brazil, South America, and Latin America? Presumably, the corruption has always been there. What do you account for the new focus on this?
Well, Mike, as you know, I go back to the days before there was an FCPA. And, you have written extensively, and I have enjoyed, the history of Watergate leading to the adoption in the United States of the FCPA. That can be seen, I think, as civil society driving the legislation. The Watergate hearings that described the public bribery, the offshore bribery by a number of American companies, led to the adoption of the statute. I think you can find in Latin America a similar event. That is that after many years of not being very effectively investigated, particularly the Brazilians have figured out how to get civil society behind the investigations so that the most powerful politicians and corporations have to account for their conduct. That wasn't the case in the past because the civil society was not well mobilized. So I think there's a direct parallel between our experience many years ago in the United States and what's happened in Brazil, and by now ripple effect through the rest of Latin America.
Yeah, and it's always interesting how there are parallels with the FCPA and other related laws, and I think you're spot on in that observation. Now, you write in the article that, quote, any company that has entered into a transaction with a party connected to a corruption investigation or is planning to enter into a transaction with a party connected to a corruption investigation should consider the possibility of itself being implicated in the corruption investigation, end quote. No doubt this is true, I think, in a few isolated, egregious examples, some of which you've already mentioned, but isn't this perhaps painting with too broad of a brush when we consider that corruption investigation could mean any garden variety, perhaps FCPA enforcement action?
I mean, I think certainly it's the case that, and part of the point of our article was that you can do deals in the middle of these investigations and with parties who are in the middle of them or who've come out the other side of them, who've turned the corner and now maybe have the best practices, really. But I think particularly these days in Latin America and with Lava Jato and as it ripples across the continent, it is a highly politicized situation. And it is, I think, the combination of that high politicization together with the corruption, that combination that I think makes it particularly sensitive and therefore important that companies that do engage in these transactions analyze them carefully and structure them in a way to protect themselves as much as possible from the spillover effect. I mean, for example, you do see that a number of the companies that were joint venture partners, regularly did transactions with some of the major players that are the focus of Lava Jato in Brazil are coming under scrutiny in their countries just because of their long association with the Brazilian companies. No specific evidence that they did anything, inappropriate in this regard, but the fact that they were regular business partners, is raising that implication. So it's just something to be aware of, particularly in highly politicized situations.
Yeah, one of the things that the article says is that you want to try and ring fence the corruption. You want to isolate the problem. And obviously, if this is a company that has a rogue, manager from one country or one transaction, it's a lot easier to isolate that from the rest of the company and go forward on the part of the unaffected part of the company. But as Cynthia says, most of the major players in the Brazilian investigations have had their CEOs involved as a key player in the transactions. When you have the whole company, the top level of the company involved, it's a much different risk profile for anybody doing business with that company.
Yeah, and that's certainly true. An issue that's I've long been interested in is are companies that resolve FCPA enforcement actions, necessarily bad, corrupt type companies. And to be sure, in certain cases where there's active participation by executives and the bribery scheme was orchestrated from the corporate boardroom, one could, easily make that conclusion. And to be sure, some of the recent examples coming out of Brazil and that region are very egregious instances of corporate bribery orchestrated at the highest levels. But what would you perhaps say to some people in this space who automatically label a company that resolves an FCPA enforcement action, whether that enforcement action concerns SEC findings or a DOJ non-prosecution agreement, the absolutist position that companies that resolve FCPA enforcement actions are bad, unethical companies? How would you respond to that?
I did an investigation of Lockheed Aircraft Corporation in the mid-'70s, where the CEO and the chairman both were forced to resign. And I spent 14 months doing it. I will tell you that it was a small group at the top, a small group who were paying the bribes. That was a very good company. I think the same can be said about some of the Brazilian companies where the named individuals, the most involved people, have their names in the name of the company. But that doesn't mean that all of the people who have devoted their lives to that company are bad. On the contrary, in my experience over all of these years is that these schemes are tightly held and very, very constrained. And most of the people involved in the company are mortified to learn that they were working for a company that didn't play by the rules.
Yeah, and it's the related question: how do you take the ethical or moral pulse of a business organization that may have tens of thousands, if not hundreds of thousands of employees? It's sometimes not as simplistic or absolutist as some people may make it out to be. Now, your article.
Well, and let me just add to that, build on that. And it's quite interesting if you look at the recent dispositions in Brazil. Most of the fines, which are whoppingly large, are paid over a long period of time so as to clearly let the good part of the company survive after surgically removing the corruption or the infection.
Well, and the other thing I would say, which I think Brazil shows us, right? When you look at what's happening in Brazil and Lava Jato, you basically see a huge segment, political segment and business segment within Brazil implicated. It was frankly a way of doing business, not to excuse it at all, but it was a broad way of doing business there. So it is something that I think you're seeing, as Dan mentioned before. There's kind of a sea change there, that society's no longer permitting that as a acceptable way of doing business. And I think part of the problem was that in that during a period of time, it just became even though it was illegal, it was just culturally acceptable to act in that manner.
Well, sorry, this is something you've heard, but I haven't said it to Mike. Before the FCPA was adopted, it was tax deductible in the United States, read morally acceptable, to pay foreign bribes. Reasonable and ordinary and necessary, or whatever the language of the tax code. So, we're seeing the same cycle being played out in Brazil, a change in the civil society's perception of acceptable.
Now, your article also mentions a couple more general topics that should be familiar to an FCPA audience or white-collar audience, and one is the so-called Yates Memo, which was a September 2015 DOJ policy document that supposedly focuses on individual accountability and the notion that to receive any cooperation credit, a company must information about individuals involved in or responsible for misconduct. Now, Ms. Yates left the DOJ in January. Is the Yates memo still relevant? Is this still an issue on the radar screen of your clients?
Well, obviously, the Yates memo is one of a long series, starting with the Holder memo, then the Thompson memo, then the McCallum memo, then the McNulty memo, then the Phillip memo. So, the department has a habit going back to 1999 of issuing these. I wouldn't be surprised if the Sessions DOJ, whoever ends up issuing the next version of that, as they sort of put a spin on how they will treat the prosecution of corporations, and that's the basic topic here. Obviously, the Yates memo got a lot of attention because of its focus on prosecuting individuals.
And prosecuting individuals has always been part of the DOJ, and for that matter, SEC's talking points when it comes to FCPA enforcement. Now, since the Yates memo, again, this was issued in September of 2015, the DOJ has resolved 17 corporate enforcement actions. Not a one has involved related DOJ charges against company employees. So what do you think accounts for this gap between DOJ rhetoric and the reality of what's actually happening?
Well, point one is we at Shearman Sterling have been publishing our FCPA digest for 20, 25 years, okay? We have collected that kind of data in one form or another. But I've always said it's a small data set. So it's very hard, even in a boom year like 2016 was, to figure out exactly what the trends are. The second thing is, as you have pointed out several times, Mike, the individuals are a whole lot harder to try than the corporations, because most public corporations don't go to trial. They, in fact, want to get this off the headlines and away from their story and their narrative, so they accelerate the process by doing investigations and cooperating extensively and, getting rid of anybody that looks like they were improperly acting against what is the company's policy. So, obviously you have to look at the long trend to see whether the Yates memo and pursuing individuals is actually going to happen or not. It's a fair question and something we all should look at. But I will tell you, again, in talking with Cynthia's clients about this, individual liability was a very important conversation.
Yeah, and I should mention for listeners' benefits, if the Shearman and Sterling FCPA digest is not on your FCPA reading stack, it definitely should be. It's one of the more informative and enlightening periodic FCPA publications that's put out there, and Dan and Philip Urofsky and others at your firm do an excellent job with that. Another topic that's noted in your article, and corrections can continue for years, often without a clear end date. And that is most certainly true in the FCPA context. And before we perhaps get to some recent developments there, Cynthia, could you perhaps comment on the dynamic of corruption investigations makes it difficult perhaps for some companies indirectly implicated to sort of draw a line around the conduct when the investigations can go on for so long?
Yeah, no, that is definitely a real challenge, bringing together the FCPA timeline with transactional timelines. It was, right after the question of how big a fine do you think it's going to be, came the question of when will this be resolved, Dan? What's your estimation? Will this be done next week? Will this be done next month? Because the transactional timeline, no matter how much and how hard the DOJ works to shorten the timeline and do something less than these multi-year investigations, my guess is it's never going to really match what the transactional people are looking for, because they're looking at weeks or months, short number of months at the most. So
and
marrying those two is a huge challenge.
And when transactional clients, that this is very likely, if it follows a typical course, to last 2 to 3 and perhaps even 4 years. What's the typical client response to that?
You're a lousy lawyer.
They blame it on you, right?
Make it faster. It must be able to be accelerated. Well,
no, I say that facetiously, but it's important that one of the great cultural dynamics between Cynthia's client base and my experience has been they are used to negotiating a private transaction, no substantial government involvement, and so they can set the timeline. They can go to the counterparty across the table and say, look, if you want this transaction, we've got to close it by Tuesday or a month Tuesday, whatever. So they're used to having the timeline within their control. And the idea that the timeline is not within their control is a very hard concept to sell. They will, after they ask how long, then they will ask, well, we'll get an indemnity because we know it'll take a long time, and then we explain that the indemnity won't help. And so the whole purpose, the article we're talking about, is to bridge this cultural difference between a largely self-contained private negotiation and the injection of an external government-driven process.
Yeah, and last year, 4.25 years was the median length of time companies that resolved FCPA enforcement actions in 2016 were under scrutiny. So, there were some that were obviously below that the figure, and some that lasted 5, 6, 7 years. And I think with good reason, the DOJ and the SEC have come under some scrutiny and some criticism for the length of time that FCPA investigations last. And to close with sort of a recent development, the DOJ's new acting principal deputy Assistant Attorney General Trevor McFadden recently said that his intent is for FCPA investigations to be measured in months, not years. Now, as I pointed out on my website, the DOJ basically said the same thing in 2005. Do you believe that going forward we're going to see FCPA investigations wrapped up in months, not years?
No. I mean, there are all sorts of problems. Fundamental to an FCPA investigation is gathering the evidence over there, offshore, foreign. That alone makes it more complicated. Due process makes it more complicated. They cannot bring a corporate resolution unless they credibly can say to the corporation, cooperate or we'll prosecute you. They certainly can't bring an investigation against an individual who has no alternative but either to be exonerated or go to jail in a short time frame. Our whole theme in this article, as we said at the top of this program, was to help corporations decide whether they could ring-fence the corrupt conduct and deal with the clean part of the company. And that's the way you shorten the time frame.
You deal with the time frame.
Yeah.
You basically try to the transaction that you want to do, you have to try to essentially put a cocoon around it so that you are able to execute that transaction largely no longer worried about the consequences of the conclusion of the investigation and whatever fines or other remedial actions are taken by the government with respect to the corrupt conduct. So you basically look at the transaction you want to do and try to make sure that the corrupt investigation, even in the worst case scenario, is not going to harm the fundamental value of what you want to do, is not going to, that you are otherwise able to realize the business and the sort of agreement. You're able to implement the agreement with that, regardless of what the outcome of the investigation is.
Yeah, this is building on the point I made earlier about the Brazilian fines being stretched over years. most of the time, prosecutors don't want to kill the company. They want to get to the misconduct. And if you can do the cocoon that Cynthia was talking about in a way that the government recognizes that transaction is not tainted by the larger problem of corruption, you can do your transaction. Conversely, where you can't get that watertight capsule, it's very hard to do the transaction.
Well, thank you both for joining us today. The guests today have been Dan Newcomb and Cynthia Urda Kassis, both attorneys at Shearman and Sterling. And the article they have been talking about today is titled Transacting Business During a Corruption Investigation. Thank you both for sharing your unique insights with FCPA Flash podcast listeners.
Our pleasure.
Thank you.